Always is a strong.
All
Always
right,
is a
let's
strong.
go on the record. Good afternoon, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today I am going to let you know if I found probable cause based on the police reports that I've read, and then we will talk about release conditions. Please note that today is not your trial date, and I encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by counsel, either from the public defender's office or if you have private attorney, I encourage you to speak with those attorneys before speaking on the record. I have reviewed the probable cause affidavits, and I will let you know when you come up if I found probable cause, and then you can talk about, tell me whatever you want to tell me in regards to setting a bond. And of course, that's only if you can do that without talking about your case. For those of you who are represented by private counsel, they normally come to the courtroom. And if they're not here, you can let us know, and we will see how we can facilitate you through that process. But I encourage you and I ask you not to say that you're represented by a particular private counsel only because you know their name, or maybe because they've represented you a year ago or 2 years ago, unless you've retained them for this case, or you have them on a permanent retainer, they're not representing you. And so I'll tell you this because sometimes people say, yes, I have an attorney, and when we call them, then they tell us they're not representing you on this case, all right? So just please bear that in mind. All right, we will start with Darlene Cronk,
North Broward, Your Honor.
okay? All right, Ms. Cronk, you're before the court, ma'am, for count one is DUI, alcohol, or drugs. Counts 2 and 3 are traffic infractions not for magistrate. The court does find probable cause, and now here as to bond.
Your Honor, I'm going to be asking the court to consider a pretrial release for Ms. Cronk. It's my understanding she has no prior criminal history. She's a lifelong resident of Florida. She lives by herself in the same apartment for the last 4 years. She's had the same job for the last 13 years, working in financing. So I think she'd be a very good candidate for pretrial release. Unfortunately, she does not have her phone, so she is not able to contact anyone. That's why I think pretrial release might be a good option for her.
Okay,
I have no objection to pretrial, Judge.
okay. All right, then, Ms. Cronk, you will be released to pretrial supervision services. The deputy is handing you the address and the directions to pretrial. You must report within 24 hours. Failure to do so, a warrant will be issued for your arrest. And also, just, keep in mind, no alcohol or intoxicants, okay? All right. Okay.
All right, good luck.
Amanda Armbrust. She bonded, okay. Selenia Brown.
She's here, present judge. Come on up, ma'am.
All right, Ms. Brown, you are before the court this afternoon for one charge of trespassing, and the court does find probable cause. What does Ms. Brown wish to do?
Judge, I'm going to be asking if the court would consider an ROR on Miss Brown's behalf. I'll see if the state has an objection to that.
Is she staying anyplace?
Ms. Brown's address, address on Green Street in Hollywood? What's her address?
That's the address she is.
Right.
That's what she's advised in Hollywood.
Well, who lives there?
Me and my husband.
Okay.
I see no local priors, Judge.
Okay.
Still up to your car when it's underground.
All right, I will, ROR Ms. Brown. She needs to know that she cannot, go back to 301 East Dania Beach Boulevard. I believe that was the address.
Yes.
She's been trespassed from there, and per these, allegations, she was told to leave and then returned 20 minutes later, so Ms. Brown understands that she's been trespassed from this location and not to return.
You understand? Yes.
Oh, it's gotta be a yes and not a mm-hmm.
Yes.
Okay, good luck.
Thank you, ma'am.
All right, La Porsche Hunter,
She's tired.
Judge bonded, Miss Brown bonded.
Hunter.
Oh, Hunter? All right, I'm sorry.
All right, Ms. Hunter is before the court for one count of burglary, occupied structure unarmed. Count 2 is grand theft. Count 3 is felony violation of probation. It has a no bond hold. And Ms. Hunter does have court tomorrow before her felony division at 8:30.
And, Your Honor, I'm
Yes, as to bond?
Your Honor, considering that she's on probation for aggravated assault and the allegations in this case, state would request a $3,500 bond on count 1
Okay,
and no return.
okay.
Well, in light of the no bond hold, Judge, she's going to have to go in front of her division judge.
All right, so 3,500 on count 1, 1,000 on 2, and she's got a no bond hold on 3, and also, ma'am, no return to this location. Okay?
Yes, ma'am.
All right, good luck. And then Pamela Mendez Estrella.
Here, main judge?
All right, ma'am, you are before the court. Count 1 is possession of cannabis, 20 grams, over 20 grams. And count 2 is violation of probation with a no bond hold. The court does find probable cause. And you have court tomorrow in your felony division at 8:30, and your bond on count 1 is $1,000. Janice Giraldo.
She bonded, Your Honor.
Okay, thank you.
She's approaching judge and she declined the services of public defender.
Is there bond posted? All right, so, Ms. Giraldo, you are before the court for possession of cannabis over 20 grams, possession with intent to sell, manufacture, or deliver cannabis, possession of drug paraphernalia, attaching a registration license plate not assigned, and failure to register motor vehicle. And the court does find probable cause as to all those counts, and I've also been advised that your bond has been posted, okay?
Thank you.
Good luck. George Del Greco.
Private counsel for George Del Greco.
Okay,
That's your attorney.
Hello.
Island.
We have probable cause, and the state and I have come to an agreement of $1,500 bond with no contact.
Okay,
Just for record purposes, this is based on the fact that Mr. Del Greco has no history and also just the specific allegations in this case.
all right, and you agreed on 1,500?
Correct.
All right, so Mr. Del Greco, the court does find probable cause. Can you see your attorney on the screen?
Yes.
All right, so there's an agreement for a $1,500 bond. And is there anything else that's been agreed to?
Just no written contact.
Okay, and he understands no contact, okay? All right.
Your Honor?
Yes,
Can I
yes, sir.
speak?
Yes,
My wife and I are raising 3 grandchildren. We've had them for 8 years, and they're 12, 14, 16. And no contact would be pretty much impossible to do because my wife is ill and takes a lot of medication. So it really takes two of us to try to get those kids to school and raised in basketball, YMCA, and all that. Is there any way we could get around that? I have to not be there.
All right, I understand your situation, but I also understand that these are teenagers. Please,
Well, 12.
right, at this point in time, it is going to be a no contact order. You can speak with your attorney further about, any other conditions, okay?
All right.
All right, sir, good luck.
Thank you, Your Honor.
Thank you, counsel. Michael McDaniels.
Good afternoon.
Good afternoon, Mr. McDaniels. You are before the court. Count one is aggravated assault with a deadly weapon. It's a domestic in nature. Count two is throwing a missile into a dwelling or a vehicle. Count three is possession of a weapon or ammo by a convicted felon.
Your Honor, in addition to the bonds that were set on counts 2 and 3, I'm not certain which judge, I think that's, yeah, Judge Siegel signed the warrant. I'd be requesting a $15,000 bond on count 1. This is based on the allegation that the firearm was actually discharged. The detective notes in the warrant that they examined the vehicle and a hole in the window, which appears to have been caused by a bullet, was witnessed. Law enforcement also found a casing in the scene where the alleged shot was fired, corroborating the victim's version of events. In addition, Mr. McDaniels has the prior drug conviction that's referred to in the report, where he was sentenced to 20 months in state prison. 2 years before that, in 2012, he was convicted of carrying concealed firearm.
Okay?
Judge, and speaking, Mr. McDaniels, I believe we have an agreement with the state that is reasonable. Nothing to add at this time.
All right, 15,000 on count one, and then the other standard bonds are in place, okay?
And, Your Honor, that would include no
And
contact?
I wrote it, yes,
Oh,
but I
thank you.
didn't say it, no victim contact.
Thank you, Judge.
Tarek Guy,
Mr. Guy,
or
come
is
on.
it?
He's approaching, Judge.
Michelle.
All right, Mr. Guy is before the court for aggravated battery, where the offender knew or should have known that the victim is pregnant. The court does find probable cause. And I'll hear as to bond.
Your Honor, based on the physical condition of the victim, the state would request a $7,500 bond and no victim contact.
And does Mr. Guy have priors?
I did not that I'm aware of, no.
Okay.
Judge, that'd be a touch out of reach for Mr. Guy's family. As you heard, he has no prior contacts with the criminal justice system. He's 25 years old. I did advise him there's going to be a no contact order in place. He'll be living Sharpner Park. He'll go to live with his father, who resides in Tamarack. Now, Mr. Guy is working. He works for H&J Contracting, which is a construction company. He's been there about 5 months. He only gets paid $8.50. So he's going to be relying on his father to help post his monetary bond. He believes that the court were inclined to set somewhere around a $3,500 bond that his father could afford that. So that's what we're at this time, Judge.
All right, at this time, I'm imposing a $5,000 bond, no victim contact until further order of the court, okay? Jonathan Moreno,
Moreno, come on up, please.
It was halfway there.
all right, Mr. Moreno, you are before the court. Count one is DUI, alcohol, or drugs. Count two is DUI with damage to property or person. Count three is careless driving. Count four is failure to wear a seatbelt, which is not for magistrate. Counts 3 and 4 are traffic infractions, not for magistrate. The court does find probable cause.
Judge, at this time, his bond may be already paid. Can we ask confinement status to see if it's been paid?
All right, they're checking.
Thank you.
It's not showing yet.
Yeah, it's gonna be posted.
All right, so he has a total of $1,500 in bond.
Mr. Ayala?
Justin Ayala,
He's approaching, Judge.
When's he scheduled for court tomorrow? Ayala?
all right, Mr. Ayala has two misdemeanor capias before the court. One for possession of cannabis, 20 grams or less, and the other is for possession of drug paraphernalia. Looks like Mr. Ayala failed to show for his status hearing on April 11th. So the court finds probable cause.
Judge, we're gonna be asking if the court would consider resolving this matter today.
State has no offer, this is drug court,
Oh, it's drug court.
yes.
All right, so he does have court tomorrow, so he'll be able to before the drug court judge tomorrow, okay? Ilan Vasquez,
Judge, Mr. Vasquez is approaching and he declined to serve as a public defender. All right, what's the phone number you said?
all right, sir, do you plan on hiring a private attorney?
Yeah, because I don't know what else to do since it's my first time that I've been arrested, so I'm not sure if I can represent myself or just to get a lawyer.
Okay. Well, you are before the court today for one count of, count one is DUI. The second count is DUI with a breath level greater than .15. So the court does find probable cause. Does Mr. Vasquez have any priors?
None that I see, Your Honor.
All right. So, Mr. Vasquez, your bond, your total bond is $1,500. 500 on count one and 1,000 on count two. All right, sir, good luck. Lamont Dixon,
He's approaching, Judge, you see what I mean?
all right, Mr. Dixon is before the court for petty theft. And, I find probable cause.
Judge, at this time, nothing to add from the defense. I'm gonna be contacting Mr. Dixon's friends to post his monetary bond.
All right,
What's that?
Mr. Dixon's, total bond is $750 and no return to Walmart on Turtle Creek Drive. Do you understand that, sir?
Yes.
All right,
Yes,
sir,
ma'am.
good luck.
I'll call him afterwards.
Brian White,
Mr. White, come on up, please.
Good morning, Your Honor.
good afternoon, Mr. White. You're before the court for 3 counts of failing to register, and the court finds probable cause. As to bond,
Your Honor, the state would be requesting $5,000 per count.
okay?
Judge, Mr. White did advise me he's looking forward to having his day in court. He's right now living in Ohio. He was extradited down here. He's 39 years old. He's working and living there. He works at a place which builds seats for Jeep Wranglers. He just got that job about 5 months ago, making $15.63 per hour. And he's working, and he's living with a coworker, and his share of the rent is $500. Now, he's gonna reach out to friends and family to see if they can help him post a monetary bond. He believes if the court were inclined to set a bond of about $1,000 on each count, that's something that he may be able to afford, so that is what we are requesting for at this time, Judge.
Your Honor, just to advise the court, I'm sorry.
Yes, go ahead.
So far, I see out of the state of Michigan in 2012, he was convicted of failing to comply with reporting duties as a sex offender. Actually, he was arrested in 2008 as well in Michigan for that offense. Let's see. In California in 2009, he was arrested on a fugitive warrant. And in 2012 in Alabama, he was arrested on a fugitive warrant. Without an appropriate bond, I have concerns about his future appearance in court.
All right, I am going to impose a $5,000 on each count at this time, okay? Eric Clace,
Mr. Clace is here present, Judge Amain. He is approaching.
All right, Mr. Clace is before the court. Count one is possession of morphine. Count two is possession of alprazolam. Count three is possession of drug paraphernalia. The court does find probable cause.
Judge, as being Mr. Class, we're going to be requesting a phone order.
Okay, I'll sign the phone order. Does the state wish to be heard?
No, Judge, thank you.
Okay. All right, finding probable cause, the standard bonds will remain, okay? Ian Schulman,
Mr. Shulman, come on up, please.
all right, Mr. Schulman is before the court. Count one is possession of cannabis, 20 grams or less. Count two is possession of cocaine. Count three is possession of drug paraphernalia. Count four is a felony violation of probation, which has a no bond hold. And count five is a traffic infraction, unlawful speed, which is not for magistrate. Mr. Schulman does have court tomorrow before his felony division judge. The court finds probable cause. And the bond on count two is $1,000. Okay? Andrew Dalbert,
He's approaching, Judge.
all right, Mr. Delbert, you're before the court. Count one is possession of cocaine. Counts two and three are felony violation of probation with no bond holds. The court finds probable cause. Your bond on count one is $1,000. And as to the violation of probation, you have hearing tomorrow before your division judge, okay? And then Tony Sherrod.
He's approaching, Judge.
All right, Mr. Sherrod, you are before the court for 6 counts of violation of felony pretrial. And those are all not for magistrate.
Yes, you're talking. Oh, never mind.
And then count 7 is a misdemeanor capias with a $200 bond. So the court finds probable cause. I'm not sure when Mr. Sherrod goes to court, okay? All right, good luck, sir. And then from this morning, Eric Bath.
He's here, Brett.
All right, so Mr. Bath is before the court this afternoon for failure to register or provide information. The court does find probable cause. And I'll hear from the parties as to bond.
And, Your Honor, well, the state has also, as I know the court's aware, has filed a motion to revoke. He
Yes.
is out on bond on a case. I was hoping if we could address that matter first before addressing the bond on the new case, Your Honor? If that
All
would be
right.
acceptable to the court.
Does anyone want to respond to the motion to revoke bond?
Your Honor, there was some additional information I wanted to bring to the court's attention, why I believe certainly that his bond should be revoked and why I believe a no bond hold in that case is necessary and appropriate. As you can see, Your Honor, he is out on bond for possession of firearm by convicted felon. Actually, the state filed an ad charge to that of carrying concealed firearm. He is now before the court for failing to register as a career offender, and as you can see, he's been a prison releasee reoffender, a habitual violent offender. It's worth noting, Your Honor, that Mr. Bath's criminal history is just full of violent prior offenses. Your Honor, in 1991, he was convicted of attempted murder in the first degree, sentenced to 20 years in Florida State Prison. In 1986, under the name Eric Robinson, he was convicted of aggravated assault with a deadly weapon, sentenced to 5 years in state prison. In '86, he was convicted of robbery with a firearm or deadly weapon, sentenced to 8 years in state prison. 1985, he was under the name Derek Bath. He was convicted of possession of cocaine. In 1982, he was convicted of battery on a law enforcement officer. And again, in a separate case in 1982, he was convicted of manslaughter and sentenced to 2 years in Florida State Prison. As Your Honor can also see, as I mentioned some of his aliases, you can see on the booking sheet other aliases he's used. I think the aliases are particularly relevant considering he stands before the court today on a new charge of not lawfully following his registration conditions. And those clearly are, that law and those requirements are law for a reason. It's particularly put in place for a reason when we are dealing with an offender like Mr. Bath, who has a lengthy history of committing violent acts against people. Your Honor, it is for these reasons that I believe that his bond should be revoked in the pending matter, that he should be held no bond.
Okay,
Judge, my understanding is the case that he's currently on, I believe he's been out of custody for 4 months. He did inform me he has a court date coming up. He is represented by the Public Defender's Office. At this time, Judge, he's been looking for employment. He finally found work working at a moving company where he was actually scheduled to start today. Judge, that opportunity he doesn't want to lose. And the reason why he doesn't want to lose it is because he has grandchildren that are depending on Mr. Bath for financial support. Judge, if you go ahead and revoke his on the case that he's currently out on and hold him no bond, that's the most egregious sanction that this court can impose. At this time, I'd ask the court to consider something less restrictive. I would ask the court to consider supervision. In fact, I would ask the court to consider level 2 with a monitor, so that we'll know where Mr. Bath is constantly at all times. He'll be supervised, but at the same time, level 2 would allow him to work, take advantage of the opportunity he was given, so he can provide for his grandchildren. So that's what we're asking for at this time, Judge.
And Your Honor, I just want the court to be aware, because I think it's relevant towards the potential consequences he faces if convicted of the underlying offense. The state, March 19th of this year, did file a notice to declare Mr. Bath a habitual felony offender.
okay. All right, having heard from both sides as to case number 19-1968 CF10A, the state's motion to revoke bond. Mr. Bath is out on a $5,000 bond on a charge of possession of weapon or ammunition by a convicted felon. And today he's before the court for failing to register to provide information as a career offender. The court is going to grant the state's motion to revoke bond. And as to case number 19-1968 CF10A, Mr. Bath will be held no bond until further order of the court. If the state will prepare an order, I'll
Yes.
sign it.
And Your Honor, just for record purposes,
Yes,
I imagine, even though he wasn't out on bond originally, Your Honor, at the time of this incident, he's already been arraigned on that case. So there are release conditions on the carry and concealed firearm.
okay,
So I was going to include that in the order as well.
so there,
I apologize, I didn't realize that there was a second count when I prepared the
okay,
motion.
okay. So you,
But that way he'll also receive gain time on both counts.
okay. All right. And then as to the new arrest,
Your Honor, I'd be requesting a $10,000 bond on the new offense.
okay. All right, I'll impose a $5,000 bond on the new charge, okay? All right, good luck, sir. So that was Mr. Then, on the misdemeanor docket, we have Judino Dennis,
County, Your Honor,
okay?
he was released.
All right, thank you.
Yes, ma'am.
So we'll delete that from the docket. Bontavious Days. Mr., Vontavious Days.
He's approaching, Judge.
All right, Mr. Days was arrested on May 25th, so he's back for a second look at his bond status. How much bond is Mr. Days?
Judge, my understanding he has a parole violation.
He does. He does have a no bond hold on a parole violation.
But I still,
Well, so then we're deleting this hearing then?
Well, I don't know what Mr. Days wants to do.
I want to get rid of it any way I got to. I got to go see CRD regardless. I'm going to have to take the trip to South Florida. I won't be long, but I need to get this out the way.
Okay.
Or if I can set- I'll make an offer, I just need one moment, Your Honor.
Okay.
Okay. Yeah, the offer would be an adjudication time served, and I know I make this request of the court all the time. I just ask if Mr. Days could be advised not only that no one here knows what effect this could have in his parole hearing, but also to make sure he's aware that, from what I can tell, the state has not made a final decision on this matter. So I just wanted to be aware of that as well.
All right. So the first thing, Mr. Days, is that you do have a parole hold, and at this time, the state has not formally filed this disorderly conduct charge. So if you take a plea, you're taking a plea on a charge that's not yet filed. You're certainly allowed to do it, but I'm advising you that, you're taking a plea on a charge that the state hasn't even decided if they're gonna file those charges.
Well, why am I in jail then if they haven't filed it? That's craziness.
Well, how the law and the Constitution works is that, everyone has the time in which to, one, file the charges and to do an investigation. So that's why, you get arrested, and then after that, the state has to determine whether or not they're gonna file the charges. So what do you want, knowing all of that, and knowing that on your parole matter, no one knows how taking a plea here today on a case that's not yet filed, how that is going to affect your parole hearing. So,
I want to be done with this, but since they don't see if they're going to file, they don't file when they come. They might send me up there anyway just because I came in contact with them. So I might as well take care of the business because I got stuff to do, man. And I ain't trying to be sent around here for no reason, man.
Let the judge know what you want to do, sir.
oh, I don't know that you're sitting around for no reason. There is a parole violation that has a no bond hold. So it's not the state. All right, let's.
You know how long it's going to be before I come back? Right now they don't file or not? How would I know?
Well, I can't tell you when the state's going to file this charge, sir. I can't tell you that right now. Or if they will file a charge. They might not even file a charge. Nobody can tell you right now. It's pending.
All right, well, I'll sit back then.
Okay.
I hope.
Thank you, Judge. No action at this time.
Okay, good luck, sir. Samantha Steers.
You handled that this
Oh,
morning?
we did that. I was like, okay. And then Alexander Tucker.
Mr. Tucker, come on up, please. They're going to assist them, Judge, right now.
Okay.
Hold on 1 second, sir. They're coming. They're going to bring it. Mr. Tucker is here, present, Judge Amin.
All right, Mr. Tucker was arrested on May 25th, and he has 2 counts of trespassing. What's the status on
Judge, my understanding is he has a $100 bond, and speaking to Mr. Tucker right now, he wanted me to ask the court if the court would consider resolving this matter today. Is that correct, Mr. Tucker? We would like to know if the state has a plea offer for Mr. Tucker.
Excuse me, the offer be a withhold court cost on both counts, no return, and the trespass occurred at the Plantation Motel, 950 South State Road 7 in Plantation. Yeah.
Judge, Mr. Tucker, I just explained the plea offer from the state. I did explain to him as far as the special condition, no return. The only request we're going to be making is, Mr. Tucker did advise me, he left some personal belongings there. I believe it's a hotel or motel.
Yeah.
If he can go one time with law enforcement to retrieve those belongings, and he wishes to accept the state's offer.
All right, if the stuff is still there, but yes, one time with law enforcement. All right, so Mr. Tucker, please raise your right hand as best you can. One hand, I need to see the right hand. Okay, do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can get your hand down. Mr. Tucker, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
Is anyone forcing you to resolve this
No,
case?
no,
Are you under the influence of drugs or alcohol?
no.
Do you need any more time to speak with your attorney?
Do you need any more time to speak to me?
Is only on my feet.
Excuse me?
Only on my feet, I got it injured in here.
I'm sorry.
It's-
Your foot? Mm-hmm.
It is injured in here.
It was injured in here?
Yeah, falling off the top bunk, bed, it fell down, and I'm under the doctor's getting x-rays and whatnot on it.
Oh, so you're getting now?
Yeah.
One moment, Judge.
Okay.
Clerk? It's, while they're looking. 950 South State Road 7 in Plantation. What? Plantation Hotel. They took the simple route.
Judge, this is an unusual request. And speaking with this gentleman, my understanding is he fell off his bunk, he got hurt, and he's getting treated right now from a doctor. I believe the doctor's supposed to come up to meet him tomorrow and let him know exactly what's going on, and he wants to hear that news, but he wants to accept the plea offer. So he's asking if you could reset it for tomorrow so then he can hopefully see the doctor in the morning, so then he can resolve his case. That's what he's asking me to ask the court.
Okay, we'll reset till tomorrow.
Thank you, Judge.
All right, let's go to the felony docket, and then Fabian Hawthorne.
Mr. Hawthorne, come on up, please.
All right, Mr. Hawthorne was arrested on May 24th. He does have 2 felony charges. What's the,
Judge, I believe, I didn't request anything of this court. Mr. Hawthorne, thought his family was gonna be able to afford to post his bond. Unfortunately, they have not because he's still here in custody. Having said that, Judge, when I reviewed the PCA affidavit, my understanding is the date of offense on this case is July 16th, 2018, in which allegedly Mr. Hawthorne cashed a check and provided his identification. In speaking with Mr. Hawthorne, he's letting me know he wanted me to tell the court He never knew that there was something wrong with this check. He actually worked for the person they paid him with this check. That's why he presented his identification. From what he's telling me, he will be coming to court, and he's looking forward to speaking with his public defender to tell him all these facts, Judge. But right now, he's not in a position to post any sort of monetary bond. He's homeless. I'm asking this court at this time if the court would consider releasing him on pretrial release.
Your Honor, the state would object. It's a filed case. He's going to be scheduled for arraignment. The state had to extradite Mr. Hawthorne to Broward from Houston, Texas. Your Honor, the information was filed in November of last year. It took a matter of time to locate Mr. Hawthorne. A concern that increases now that we're being told he's homeless. Even if you put him on pretrial and he doesn't report, they're not going to have an idea where to look for him because they don't have any kind of residence to look for him at.
Well, Judge, I know the state, I don't know if it was the state's intention to phrase it this way, but it made it look like Mr. Hawthorne thought there was this outstanding matter, and then he just basically fled to a different jurisdiction. He didn't know anything about this case. Basically, he thought he honestly got paid for a job, presented his identification. With those proceeds, he tried to move up to where he was extradited from for new job opportunities. That's when there was an outstanding warrant, and he was brought down here. Now he's down here, he's gonna stay down here, but unfortunately, right now, he doesn't have a place to live. That's why I'm asking for pretrial release. Now, he does have extended family here in Fort Lauderdale that he's gonna be reaching out to, and hopefully he can stay with them. But he wants to have his day in court to let them know, as far as there wasn't anything nefarious as far as him presenting his check. He thought it was a legitimate check.
And, Your Honor, the reason I brought it up is because, as Mr. Romero just said, his ties obviously down here weren't strong enough for him to pick up and move to Texas to look for work. Just to release him now at this point, there really is nothing keeping him here. And that's why I also brought up, without having any kind of residency, where does law enforcement even start to look for someone if a warrant is issued?
Because he does have family here in Dade County, his mom, and that's where he's gonna go and talk to her and let her know that he's here, and hopefully he can stay with her.
Based on the allegations and what I've heard here today, I'm surprised the bond is only $2,000, so I'm gonna deny the motion, okay? John Seeger,
He's here present.
all right, Mr. Seeger is before the court.
It's 30-day motion, Your Honor.
Yes.
We have now filed an information. Mr. Seeger is entitled to an ROR at this time.
All right, is Mr. Seeger being held on anything else?
I don't believe so, but I'm not sure.
Mr. Seeger, do you have anything else that's holding you in custody?
No, ma'am.
All right, I just want to make sure. So I will grant the motion for release. The state has not formally filed the charges. It doesn't mean that they can't file it, just means that we can't hold you any longer pending that filing, okay?
Thank you, ma'am.
All right, sir, good luck. Patricia Crawford,
I believe Paul Ryan?
Paul Ryan. Good evening, Judge. How are you today?
good afternoon, Ms. Crawford. Ms. Crawford, what's the status on
State
hers?
has not filed an information on these charges. She's entitled to an ROR.
All right, Ms. Crawford, you are entitled to be released on your own recognizance as the state has not filed the charges. I will sign that order releasing you. It does not mean, though, that the state cannot file the charges at a later time, okay? So you
Yes,
need to
ma'am.
make sure you pay attention to your mail so you know whether or not you have to come back to court, okay?
Yes, ma'am.
All right, good luck.
Thank you.
Kobe Francione,
He's approaching, Judge. He's here.
all right, it's a 30-day motion, what's the status?
Your Honor, I'm not showing that an information has been filed, so he is entitled to an ROR on these charges. I would ask that there was originally a no contact order issued. I'd ask that the court advise Mr. Francione that there is a no contact and the alleged victim's name is Mateo Toro.
All right. So, Mr. Francione, the state has not formally filed the charges. I am going to sign that order granting your motion for release. And there is a no contact order in place. It still is in place. Do you understand that, sir?
Yes, ma'am.
And also, you need to make sure that you pay attention to the mail, just in case the state decides to file all the charges or some of the charges, or whether or not you have to come back to court, okay? All right, Nicholas Garcia.
Coffee, Your Honor.
Morning, Your Honor.
All right, good afternoon, Mr. Garcia.
Good afternoon.
This is a 30-day motion,
Yes, Your Honor, I'm checking the status right now.
okay?
Your Honor, information has not been filed at this time. He is entitled to an ROR on these charges.
Okay,
Just making sure that, because I see another felony case number listed there. On the
Mr.
docket.
there are two
He's
cases on the
bonded
docket?
on that.
Has he? Okay, good. It was surrendered. So, Your Honor, just so Mr. Garcia is aware, even with the ROR, there's still gonna be $1,000 bond on, actually, I'm sorry. No,
They're
he's,
both cases on the docket today.
are they both on the docket?
Yes, on
Yes.
5 and on,
Okay. Then let me just, okay. Well, on this one was $1,000 bond surrender, but he's entitled to an ROR on this.
okay. All right, so I'll grant the ROR. And then what's the status on the other one? The
That's
other
up-
one's a recent arrest.
That's the second look. He was arrested on May 24th.
Yes, Your Honor.
Wait a minute, Your Honor, I'm sorry, I need to check this, because something, I don't think the math is gonna add up on Garcia. Because it's saying 37 days, but if, Your Honor, if you know, do you have the docket in front of you?
Yes.
If you look at the 5271 CF, it says 37 days with an April 23rd arrest date. I don't know how that's possible if he was arrested May 21st on the other case. I
Oh,
think the clerk and maybe the PD is trying to give him time for when he wasn't in custody.
May I say something?
all right. Yes.
That charge, they were gonna ROR me, but somebody had posted one of my mom or my dad had posted the bond that day. Now, once they knew I was going to court to be ROR'd that day, they had taken off the bond, and then they sent me back to the cell in the main jail. And then later that night, my mom or my dad had posted the bond again, because they thought I was gonna be ROR'd. I understand what he was saying though about the time served. I'm not too sure about that, but in that original charge back in April, I was going to be ROR'd anyways. Just saying. I'm just saying. That's all I know from.
No, I don't understand. Were you, you must have been out,
I did get out. Yeah.
right? When did you get out?
I'm not sure the exact date. It was maybe like 5 days, 6, 7 days after the arrest back in April.
Yeah, so then that means this is not correct then.
Yeah, Your Honor, I can tell you right now, I did the math. When he was first arrested on the possession of cocaine on case number,
I never got a court date in the mail. I was checking every
All right,
day.
hang on, Mr. Garcia.
Thank you.
yeah, I mean, this, and I'm looking at both cases have, I'm trying to figure out which one's good. Okay. When he was arrested on 195271 CF 10A on April 23rd, he was released, I believe, on the 28th. He had 4 days in jail.
Okay,
He was then arrested again on the 21st on 196511 CF 10A.
right.
His bondsman surrendered his bond that same day. So he's had 8 days in custody since then. He's been in custody a combined 12 days
Yeah.
on 195271 CF 10A. Your Honor, I apologize, I didn't catch that. I know you granted the motion, but I would ask the court to reconsider based on this new information.
Right. And then on May 21st is the most recent arrest.
Your Honor.
And because his bond's been surrendered
For
the
the
same
same
day,
charge.
he
My
gets
car
all
as
that
well.
time.
Hold on, Mr. Garcia.
Obviously, that,
He was rearrested for the, pretty much the same charges
yes, ma'am.
within a month. So, the ROR, so I'll withdraw the granting of the ROR on this charge because the motion is not a 30-day motion. And if we consider it a second look, he's before the court again for the exact same charges. So I'm gonna deny the ROR on both at this time, okay? All right. All right, so next we have Randall Opie.
Am I able to
North
bond
Broward.
out though, Your Honor?
That's North Broward, Your Honor.
Yes, whatever bond you have is in place.
Because I had 3 people already try to bond me out this past week, and because the one was surrendered.
They didn't even send it.
No,
Not touching it.
I have a car in impound that if I don't get out fast enough, it will be sold, and I have a lot of my work stuff in it.
all right, you need to talk to your attorney about filing an appropriate motion, okay? Before your division
Okay, so
judge.
the bond is still surrendered?
Yes,
Thank you, Your Honor.
okay. Randall Opie?
North Broward, Your Honor.
And, Your Honor, the state has not filed an information on this case. He has been in custody 35 days. He's entitled to a release at this time.
All
on these
right, so,
charges.
so Mr. Opie, we're granting the motion for ROR at this time.
Thank you, ma'am.
It doesn't mean that the state cannot file the charges at a later time, so you need to make sure you pay attention to your mail to see if you have to come back to court, okay?
Thank you, ma'am.
All right, you're welcome. Gregory Getson,
He's in Conte, Judge.
Conti, Your Honor. Good afternoon, Your Honor.
Judge, my understanding is that Ray from James Club is going to be here. He's supposed to be here about 2 o'clock, and it
okay?
is now 2 o'clock. And I believe that Mr. Getson has been accepted into the James Club program. Is that your understanding, Mr. Getson?
That's actually why I was here, sir. I was coming to Hope to ask for a bark screening, maybe a mandatory court-ordered 30-day rehab. I talked to my public defender about it, but did not have any further information.
Your Honor, if I may.
Yes,
Just so the court's aware, originally you granted an ROR to pretrial with the GPS level 2. Frankly, and I don't want to speak for the court, my position is if any place is agreeing to take him and he can stay there, then, it's fine with the state since you ordered a GPS level 2.
okay,
It doesn't matter to me really where. I would ask the court not to get into, bark orders and stuff at this time because you just ordered release conditions and really that's what we were here to address.
all right. And, well, I guess if he's at James Club, that's something, they'll handle all those things.
The issue with the James Club situation.
Yes.
Was something between the defendant and the public defender's office. When pretrial contacted James Club to verify that he was coming to them, they start questioning us about their payment. And we was like, no, that's something you guys need to deal with.
Well, why don't we wait until somebody from James Club gets here? He's already been ordered on level 2 GPS,
Yes, gotta-
so,
If I may, ma'am, the reason why I wasn't released is I did not have a solid address. I was living out of my car at that moment.
Right, well, I guess if you're in James Club, you'll have a solid address.
And
is the thing.
Yes.
Your Honor, you were advised at the time of his first appearance that he was living in his car at the time, so I believe
Right.
that was the court's intent, that there be some,
First appearance was handled by a weekend magistrate. He came back for a second look.
oh, really? Oh.
So this is
Another third look.
Another third look. All right, apparently James Club is going to be here at some point in time. The release conditions is not going to change. You're been released to be on a GPS monitor. If James Club comes in and speaks with pre-trial supervision and it's okay, then I guess you'll be going to James Club. And then they can do whatever, whatever screening that needs to be done, they can, I believe that they do it there, so. All right?
Okay, thank you, ma'am.
All right, sir, good luck.
Thank you.
Larry Wamley,
He's here, present, Judge in Maine, this is approaching.
Mr. Wamley was arrested on May 23rd.
Judge, yes, he has $1,000 bond, he's still in custody, so we're asking for him to be considered be released on pretrial.
What's the deal with Mr. I have his,
Yeah, this involved, he and a co-defendant stole just under $1,800 worth of, items from Walmart. They fled in a vehicle and, were stopped at Hillsborough and Nob Hill Road with all the, stolen merchandise.
and what kind of priors does Mr. Wamley have?
Let's
Yes?
see.
Oh,
As far as Broward, a no valid DL, he pled that out, first week of May. That was after a Grand Theft Auto had been declined, May 1st of this year. Unlawful use of false name ID, he pled out in March. No valid DL with another Grand Theft Auto that was dropped, he pled that out in March. 2014 Grand Theft Auto with a VOP, 26 months in state prison. Grand theft resisting a merchant, 2013 with the VOP. Unlawful use of false name ID, 2011. Grand theft twice in 2010, VOP, a year and a day state prison. Aggravated fleeing and eluding with a Grand Theft Auto, 08, 18-month state prison. Possession of stolen credit cards, 08. Theft, 08. Dealing in stolen property, 07 with the VOP. That's the most relevant priors, Your Honor.
it sounds like, the judge, issued a reasonable bond in this case. Right? So,
Well, he's homeless, so I don't know if it's reasonable for Mr. Wamley, but I understand if the court takes no action.
okay, and then the court takes no action. Adam Klein,
Can't set a box, it's not reasonable.
all right?
Bonded, Judge?
So there's only one more person on the docket, and our Spanish interpreter is here. So is he here
okay.
for Mr. Rojas?
Rojas. He's approaching, Judge.
Morning, Judge. Good afternoon, Judge, and everybody else.
Good afternoon. So Mr. Rojas was arrested on May
El señor
25th.
Rojas fue arrestado el 25 de mayo.
So he's here
Por
for a
lo tanto, está
second
aquí
look on his bond status.
Segundo repaso de su estatus de la fianza.
He has a
Judge, he has a $2,025 bond.
Tiene una fianza de $2,500.
And speaking with Mr. Rojas, I believe a phone order was done initially.
Hablando con el señor Rojas, me parece que a phone order, una orden telefónica se hizo en un principio.
He advised me he finally got a hold of his family, and they should be posting his bond later on tonight.
Y finalmente, pues me dice que logró comunicarse con su familia y ellos estarán pagando la fianza en la noche de hoy.
Okay, so then, are you asking me to take no action?
Por lo tanto, ¿usted me solicita que no tome acción? Sí.
Okay, then the court will take no action at this
Pues
time.
bien, el tribunal no tomará acción alguna.
All right, thank you.
Thank you, Judge.
All right,
I like
thank you. Thank you. Thank you.